Hello, everyone. We'll just give maybe a minute more for everyone to join. Okay, hello, everyone. Thanks for joining us and welcome to today's session. Today, we're joined by Trina Ha, who is the Chief Legal Counsel at the Intellectual Property Office of Singapore. And Trina is going to be talking us through the draft Singapore Copyright Bill. Before we get started, I'd like to pay my respects to the Ngunnawal people who are the traditional owners of the land in Canberra, which I'm joining you from today. On behalf of the ADA, I'd like to pay my respects to their elders past, present and emerging. The Singapore Copyright Bill that Trina is going to be talking to us about today is, I think, the most significant copyright reform undertaken in Singapore in the last 30 years and has been underway since 2016. I think there are some really exciting parts of the bill that I'm keen to talk to Trina about today, and some parts that we would love to see implemented here in Australia as well. The bill is written to be technology neutral. There's a restated fair use provision. There are new purpose-based exceptions for education that will allow the use of freely available internet materials, and there are there's a text and data mining exception for computational analysis, as well as expanded rights for creators and performers. Trina, I would like to hand over to you now to talk us through the bill. Trina has some slides. I'd like to invite everyone to make comments and ask questions using the chat box along the way. You're also able to use the raise hand function, and when we see that, we'll invite you to turn your audio on, and you're welcome to ask questions directly to Trina using that function as well. So with that, I will hand over to Trina to start talking us through the draft Singapore bill.
Hello, everyone, and thank you, Ben, for that nice introduction. And I'm really glad to be back at the ADA Forum. I last spoke here in 2019, and I'm glad to be back here to show you the progress that we have made here in Singapore. You are right that it is the most extensive the review of our copyright regime in more than 10 years. Previously, we would say tackled issues and amended the Copyright Bill, Copyright Act, but this time it is a completely overhaul of our existing act. In fact, the draft bill that was released earlier this year was a complete rewrite and restructure of the statute. So before, you asked me to share about the consultation process that took place to reach the point we are here now. Before I do that, I thought I would just restate the overarching aims of the review. It is a joint review by the Ministry of Law and the IP Office of Singapore, IPOS for short. And we had three high-level aims in mind. The first, of course, that it would be reasonable to balance the interests of creators and producers with users. We would want to incentivize the creation of works while also ensuring reasonable access to the works for the good of society, such as education, preservation of historical records, technological advancements, and some of these users in turn can create new works. So where is that reasonable balance between the many stakeholders in the regime? We would also want a regime where the rights are clear so that everybody who uses or creates works understand, and there's a certain degree of certainty as well. And of course, the third aim was for efficient transaction of rights. where creators and producers are able to reach their audiences, and users can also easily seek permission to use works. So we had these 3 aims in mind, and what was also important, as you will see popping up on the screen now, if I could just have the next click. Yes, we live in a time of fast-moving technological changes. There's no certainty except for uncertainty, you could say. Every other week we hear of a new business model, a new way that copyright works are created, consumed, distributed. And so it was very important that whatever provisions, whatever new rights or exceptions we introduce are adaptable to technological changes to future-proof our act. You will see that in our draft bill, where we sought to use very technological neutral language, where it's not so much where we describe the technological functions of a device, but the intent of what the device could be capable of using rather than tied to a certain system or standard. So these are the objectives of the review. And in order to achieve these aims, it is very important, of course, to hear from all our stakeholders. As I'm sure you well know, the copyright regime, the range and multitude of stakeholders is tremendous, for individual creators, corporate creators, corporate users, intermediaries, and all kinds and industry associations. So perhaps we could move to the next slide, and I will talk about the number of consultations we had over the years. So as you mentioned, Ben, the review did start publicly in 2016. There was, of course, a lot of monitoring of developments prior to that, what was going on in the UK, as well as what was going on in Australia as well, with the report from the Commission. And in 2016, we did the first consultation where we came up with 16 proposals, what we hope to do to overhaul the regime. But we also had, we were brave to add in a ending paragraph that said, well, you know, if there's anything you would like to bring to our attention that you think we should look at, please do so. And of course, the industry certainly did. And a resounding proposal that came to our attention was to deal with illicit streaming devices. And I mean, we are not the only jurisdiction that has this issue. I'm sure Australia does as well. You know, I mean, we call them gray boxes because they are capable of accessing both legitimate as well as unauthorized content. So that was something that the rights holders, the cablecasters, the broadcasters all came to us and said that they needed some certainty in the legislation to impose liability on the sellers and distributors of such devices to stop this trade and unauthorized access to content. So that was the 2016 consultation. In 2017, we held a very targeted consultation on collective rights management. Singapore's collective rights management landscape is completely unregulated, except for the Copyright Tribunal to hear disputes on licensing tariffs. We had been hearing anecdotal feedback that more needed to be done, and as you know, around the world, a lot of jurisdictions were also looking into regulation. So the 2017 consult was a very targeted one on whether or not we should have regulations of CMOs and what would be the extent and nature of such regulation. And then in 2019, we released our report, which addressed the issues in the first two. Not every of the 16 proposals resulted in a recommendation to legislative changes. For instance, we decided not to proceed with setting up a moral rights orphan works registry. We decided that with our expanded exceptions for education and galleries, museums, and libraries, that perhaps it might negate the need for an orphan works registry. We decided to take on the industry's suggestion to legislate liability for illicit streaming devices. And we then decided as well that for collective rights management, we would actually create a class licensing scheme. It was decided that it would be what we call a light touch scheme. A light touch scheme, meaning that we would not actively regulate the the organizations. It's not a case where you have to put in an application to be licensed and you have to go through annual audits and checks. It's a class license, meaning that so long as you carry out the activity of a CMO, you are subject to the terms and conditions of this license. And IPOS and Ministry of Law also decided the government would not intervene to set tariffs, the license fees at tariffs. That would still be the domain for adjudication by the Copyright Tribunal. What a class licensing scheme would focus on is for corporate governance, accountability, and transparency of CMOs and their relationships with their members as well as the users. So that was decided. And last year, we held a third public consultation on, so having decided the framework of this class license, what exactly would we license under it? For instance, would we be talking about corporate governance standards? What kind of financial statements need to be issued? Number of meetings that need to be held? Were we going to mandate dispute resolution mechanisms for CMOs? So we held that consultation on it. We have not drafted the license terms and conditions because those will be in subsidiary legislation and that would take place next year. What took place this year is the Act itself, the rewrite of the Act. So as you know, in February, we released the draft legislation. It's a complete repeal and reenactment of the current Act. So it's basically essentially a new Act that you had to read, and of course we had to familiarize ourselves with all the new numberings because we did a complete restructure. So all the old section numbers that we're used to, we had to throw it out the window by end of this year and learn new numbers by heart. And so that was our fourth consult. It actually just ended on the 8th of April, just this very month. It was a 10-week consult ultimately, and was an interesting exercise. And it's really great to see the interest that people have in our copyright regime, not just locally. A lot of the responses came from overseas as well. So this is the timeline of the review and the consultations we had. Perhaps I'll move to the next slide, which will show you some interesting facts and the scope of the consultation. So you will see here on screen what some interesting statistics about the 2016-2017 copyright consultations. There were 2 consultations, and there were in total 94 formal written submissions from a variety of stakeholders, from music publishers to broadcasters to law firms to publishing houses to international associations as well. And we had 283 online feedback forms, because apart from asking stakeholders to write in, we actually created an online form where to facilitate, especially for individuals, to simply go in, choose the proposal they wanted to talk about, and then just type in your feedback on that particular proposal. So we made it as user-friendly as possible. We had people who would give feedback on only one proposal. We had some who gave feedback on every single proposal. It really facilitated. It was 283 submissions that the team had to plow through. And we also had the first ever public town hall for an IP consultation by IPOS and MinLaw. What we essentially did was we booked an auditorium and just invited everybody to come. I think we had definitely over 80 attendees, and it was actually quite fun because you had such a range of people. You had like companies, big tech companies there, corporate publishers and broadcasters, as well as musicians and performers, and we went through all our proposals, and as well as any concerns that people had. So it was a good, very rigorous 2 hours we had that day. And we also had academic roundtables with the professors to understand the legal implications of some of our policy proposals, and over 10 stakeholder engagement sessions. And what is interesting about this is we told the people who were there that whatever you say, we're going to transcribe, and that we'll take it as your feedback. And so we had 194 transcribed documents. This is in addition to the 94 written submissions and 283 online feedback forms. But it was great, and we did this in a very collaborative manner, that we held these engagement sessions together with industry associations and groups. It's not that every single tent was organized by us. So for instance, we organized one with the Professional Photographers Association of Singapore, one with the Filmmakers Guild, National Book Council, Musicians Guild. We met with the music publishers. We held roundtables with the Asia Video Industry Association, as well as the Singapore Infocom Technology Federation. There were a few more. So it was very collaborative in that sense. And that resulted in a 2019 report. Now, as I mentioned last year, we had intended to hold a consultation on the areas to be licensed under the new licensing scheme for CMOs, but regrettably, the whole world was hit by the pandemic, and it put a spanner in the works, in the engagements that we were thinking of lining up. But perhaps if I could see the next text box. Yeah. Well, it didn't stop us. We decided, we held it in June when we were actually in the middle of Singapore's own lockdown. And Zoom was still relatively new, but we decided it should not stop the work. So we actually did 2 online engagements. And again, we wanted to ensure we covered the spectrum of users and members of the CMOs. So we held 2. One was with users. We co-organized it with a creative media agency. And the second one, and you can see the photo on screen, was with members of CMOs. It was co-organized with SG Muso, which is an organization that advocates for the rights and interests of musicians. So, I mean, in June last year, everybody was still getting used to Zoom, but it was still a very highly interactive and engaging 2-hour session. And I recall there was somebody who kept talking, and I politely told him that perhaps it would be nice to let the others speak and share their views. And he said, sure. And then he continued writing in the chat box. So that was quite, it was fun in a way. And I think it was great to know that we had available to us all these digital platforms to continue the process, and that the consultation did not stop. And of course, could I have the third box, please? And of course, this year was the consultation on the draft bill. It ran for 10 weeks, as I said. Now, you will see the numbers are lower, only 33 formal written submissions and 15 online feedback forms. But that is because it's no longer a policy consultation. We were very clear. We have decided on the policy for now. It's not to say that this is it, we have a running list of issues that we need to look at in the future. But I mean, we have to get the bill done. So this was focused very much on legislation drafting, the clarity of the language as we move to plain English. There were, of course, we changed certain terms, certain ways in which rights or exceptions were written, like we introduced a concept of permitted use for exceptions. And so was that we were asking questions like, is this clear? Is it workable? Are there practical difficulties in implementation? So a lot of the submissions came from more of the corporate stakeholders, the intermediaries, the publishers, and of course the lawyers. We had academic and practitioner roundtables as well. For practitioners, it was very important as we created new rights and new liabilities. What are there procedurals in civil processes or criminal processes that we are not aware of that may hinder or facilitate the enforcement of such rights? We also met with over 12 stakeholders virtually to discuss use cases, because we put into place quite a lot of new rights and exceptions. And so we went through with these stakeholders, or rather they posed scenarios to us to say, okay, if this happens, does it fall under your legislation? Was that your intention? And the use cases were very useful because they help us understand whether or not our legislation was clear. Where exactly are the parameters? and helped us sharpen some of the language and exceptions as well. And it's, copyright, like I said, the range of stakeholders is so broad. Not every user or creator has access to the kind of legal resources that a lot of the corporates and intermediaries have. But we are, we are introducing new rights like right of attribution, changes in default ownership of certain commission works like photographs, sound recordings and films, which would actually impact individuals and small businesses and freelancers. For instance, a photographer now, he would be the first owner of his photographs and not the commissioning party. How does that impact on you practically? You need to think, I need to relook at my business contracts and things like that. And we wanted to ensure that, people, not just the big corporates were ready for these changes, but the smaller players and individuals. So we teamed up with industry association and had a virtual session with more than 100 creatives and freelancers to explain these new rights and provisions and what it means for them. So I think you can see from this slide that although it started in 2016, it has been a very intensive consultative process. Of course, what I didn't put here were the many phone calls and face-to-face meetings with various groups and concerned individuals and constant feedback on why you're not looking at this, why you're not looking at that, And even though, for instance, we said that this is a technical consultation on the bill, I think that there were still issues that came up more on the policy front, but as I said, we have to go to Parliament, so we will KI keep that in view for later on. Now, apart from consulting with a whole range of people, it was, well, I mean, personally, I felt a very collaborative process because we did it together with them. We held the engagement sessions together with them so that we could reach out to their members. Instead of saying, oh, come and talk to us. We work with National Book Council, who brought in I think there were 50 over writers and publishers in that room asking questions. Oftentimes it descended into a little bit of a legal clinic, but it was good because it helped us engage the sentiment on the ground and what's the level of awareness. But perhaps I'll give you an example of why I say that it was a very open consultative exercise. Now, in 2016, one of our proposals was to have a very broad-based exception for education, a purpose-based education exception, any type of material, print or online. The publishers and intermediaries were naturally concerned about how this would impact on business models, licensing models, revenue, and they brought to us a lot of information, comparative data for other jurisdictions like Canada that had something similar. And we engaged in a lot of conversations with them. And ultimately, in the end, we decided when we came out in 2019, and you will see it in the draft bill, to scope down the breadth of the exception. It is still a purpose-based exception, but for online works that are made freely available. So it is a more limited exception. We went back actually to the schools and the Ministry of Education as well to say what exactly is your concern. And the concern was that there is a multitude of materials out there that could be useful for teaching and learning. And it would be difficult if you would have to check and clear rights for everything. But if you do it in a safe space of giving and receiving instruction, project work, and if you kept it on an intranet that is controlled by the school and limited to only the school and students, it becomes a limited but very focused and useful exception. And I think it is we're on the right track, I feel, because last year when the pandemic hit and schools started closing, not just in Singapore but all around the world, and we moved to home-based learning, the access to materials online it was very important. So we scoped down the exception. It's now a purpose-based exception for online materials that are freely available. You may not, circumvent paywalls and all that to access materials. If you have to pay for, let's say, a textbook to get access to online materials, you have to buy the textbook. So So it's very, I think this is, I feel, a good example of how we consulted, we listened to the industry, and we came up with a solution that fulfills the aims of the review, but also takes into account the views of both user, the schools and students, as well as the rights owners. So I hope that fulfills your mandate for me to bring everybody through the whole consultative process that IPOS and MinLaw took. Yeah, and that ends my presentation.
Thank you so much for that, Trina. That was a really interesting and thorough sort of overview of the process, and a really detailed process that you've clearly gone into since 2016. I think just going to your last point there on the purpose-based education exception, I think one of the things that I really liked reading that was the wording around if the material is freely available and freely accessible at the time that it's accessed, then it's able to be used in that teaching environment. I think that's a really important way of framing an exception like that doesn't rely on trying to discern the intention of the person who's put the work up online in the first place. But I'll invite anyone to ask any questions in the chat box. Feel free to use the raise hand function as well, or there's the Q&A box there as well. While we're waiting for some of those questions to come in, one of the things that I'm really interested in, particularly about the bill, is the exception for computational analysis that will allow things like text and data mining. I think that's something that would be really beneficial if we were able to introduce something similar here in Australia. So I'm wondering if you could talk maybe a little bit more about that and how you see that exception working, what the thinking was behind the need for a standalone exception for computational analysis.
Sure, Ben, no problem. Well, Singapore, let me talk generally a little bit about how exceptions work under Singapore's copyright regime. So we follow the UK in that we have very specific fair dealing defenses: criticism and review, judicial reporting, current news reporting. But then in 2004, we introduced a general fair dealing defense that looks almost like the US fair use, except that we had a fifth factor, whether you were able to obtain a license at a reasonable time at a reasonable price. And the general fair dealing exception was meant to capture situations that you cannot foresee and anticipate as technology changes. We are still retaining that exception in our laws. We're retaining it, and we've actually taken away the fifth factor. Some people think, oh no, that means it doesn't matter anymore whether you could have gotten a license. That's not correct. All we are saying is that it's no longer a mandatory factor to be considered. So it's not listed there, so it's not mandatory. But in certain circumstances, the ease at which you could get a license to use the work would come into play. So that's the landscape of exceptions in Singapore. So as technology advances and we move beyond spiders and data scraping to even AI systems that can trawl the net and look for photographs, for instance, or music, or paintings that would help them to learn and all that, it became important to really address our mind to how do we support innovation, big data, and of course bearing in mind a lot of what is being scraped off is data. It's not protected by copyright. I think that's something that needs to be stressed, because everybody gets excited and say you're copyright infringement by taking all this data, but it's data per se. But yes, you may copy copyright works. You may, because if you want to teach a machine translation, you have to scan and reproduce all the text. But it's being used in what we call a non-expressive manner. It's not like you are putting together a library of films for free screening for everybody. That's not the case. You're using it for a particular purpose called computational data analysis. We chose that term, although, I mean, loosely, especially in our 2019 report, we talk about text data mining. But it's gone beyond that, right? You're not just mining text or mining data, but rather it's that you're using a computer to analyze material. And computer data analysis is broad enough to cover text data mining, machine learning. And so that's what we wanted to focus on. What is the purpose for which you are using? And that's to encourage innovation and technological development. So it was important to us at a very economic policy level to have such an exception to encourage research. Okay. So let me, then why, I know some people have asked, why create a specific defense exception? Why not say, this could fall under general fair dealing? After all, as I just explained, it is broad enough. Well, in Singapore, we are not a very litigious society. So if there is a risk that an act could be an infringement, even if an exception is available, it is unlikely that the user will proceed. Put it another way, the general fair dealing was introduced in 2004. Our first case on it was in 2018. A lot of things are settled out of court, or we're a bit risk adverse. So how do you encourage? Is it good enough to just say, well, you could do it, and you could probably fall under the general fair dealing defense, as opposed to creating a specific exception that is very targeted to allow such R&D, such behavior for R&D and innovation, and to give that certainty to users that you can do it so long as you stay within these parameters. And it was important as well to ensure it is balanced. I mean, that's one of the aims of the review, to balance the rights. And it's not a free-for-all. It's not a free-for-all. We did study the UK legislation, the EU directive, and one, you must have lawful access to it. So you may not circumvent paywalls or TPMs to access the material. That's important. And it should not be an infringing copy, unless, of course, you are perhaps doing a study on copyright infringement. But you see, if you were to rely just on a general fair dealing defense, how long would it take to create these safeguards and parameters that benefit the rights holders? So, well, I mean, it took more than 10 years to get a court case. So we thought that a specific exception that balances with more certainty what you can do and what you can prevent would, benefit both sides of the equation. And like I said, that was the second principle of the review, where rights are clear. You know what your rights are. There is a degree of certainty. Yeah. So that's the background to it. And yes, I see a question. Do rights holders voice any concerns? Oh, of course they did. I would be lying to you if I said they didn't. Definitely, there were concerns right from 2016. And well, I mean, of course, they were concerned about whether, I mean, apart from the fact, I think there were a few things we had to address. Let me be clear. First, we had to address that we were not allowing infringing uses of their work. It is a non-consumptive, non-expressive use of the work. And also, as I said, that you must have lawful access to the work. We adopted the UK, some parts of the UK provision. You must have lawful access. So I think when the bill went out, we had conversations with, of course, the rights holders. I think they were glad to see that we put in the safeguards that we had said we would do in 2019. We are still refining the provisions. What you see in the draft bill is just a draft, right? It's an exposure draft for feedback. We have gotten the feedback, and we will be relooking at some parts of it to see whether things need to be clearer or need to be addressed to create that balance that I spoke about.
And we have another question there. So how did or do you overcome those rights holder concerns? And I think that goes back to that consultative process that you've been running, doesn't it? You know, working through some of those concerns with rights owners and users and all of the stakeholders across the board.
Yeah. So one of the major things was how can they access the works? So when they saw that, you know, we kept the lawful, we put in the lawful access provision, I think, you know, that helps to allay some of the concerns.
Yeah, definitely. I think it'd be a really interesting model to start looking at, particularly here as well. And just to follow up on that question as well, how do you give them, rights owners, a level of comfort that what you're proposing won't impact their commercial markets? Was there a way of working through some of those concerns?
Well, let me put it this way. Are we actually taking away their commercial market by saying that you can scrape data? Because you have to get lawful access. Meaning, for instance, if it's a portal of scientific journals, a subscription, you need to get that subscription in order to access the works. So if your commercial model is built on you know, that subscription fee, that doesn't take it away, because you still need to pay that subscription fee to get access. And it doesn't stop actually publishers from also issuing different tiers of licenses that would include allowing them to scrape data, for instance, because, you know, and some users, actually, the research institutions might prefer that, because then you have the certainty of knowing that you can then go in and freely use the materials. And I mean, if you really think about it, how different is it from a researcher eons ago going to the library and going through like 60 journal publications over a few months and typing or writing down his thoughts, you know? It's just that now, because of technology, you do it much faster. I mean, perhaps I'm simplifying it. I'm sure it's not as simplistic as that, but conceptually, and you know, there's that analogy. And that person would have paid a subscription fee, or he would have bought those 50 journals.
Yeah, and I think there is, you know, across the bill, a really good balance between the protection of rights for users and rights owners as well. I think that shows up throughout the bill, or throughout the draft bill. Sorry, there was a question that just popped up there.
Ignore.
Oh, no, ignore. Okay, no problem. Just, I guess, staying on that, the text and data mining theme there, that would apply. Is that one of the exceptions that would then be protected from contractual override in the bill, in the draft bill?
You were going to ask me that Nimrod question, right? Yes, it will.
And so maybe that was more broadly than on protections for contractual override, because I noticed there was.
There's a question for somebody as well. Does your review deal with contracting out as part of publishers' licenses? I take it to mean that whether the licenses, because we said you need to have lawful access, right? So whether the subscription terms or license terms, you know, exclude these exceptions. I take it to mean that, and that's kind of what you're asking me as well. So we do have a provision that that certain contractual restrictions or exclusions will be void, but please remember it's under Singapore law. We do not try to say that this applies to everything other laws. So we have two categories. We have those where it is mandatory in a sense that mandatory in the sense that if you have the terms of use that say you may not data mine, that would be excluded. There's a list of that. The list includes text and data mining. Just give me a second, I need to pull it out. The list includes, computational data analysis, judicial proceedings or professional advice, and the exceptions for galleries, libraries, archives, and museums. These are the group of exceptions that we feel have very important users, and it should not be in a way undermined by contractual restrictions or overrides. So, and then there's a second group under this contractual restrictions clause where for all other exceptions, you could only exclude it if it was reasonable, if it's an individually negotiated contract and it's reasonable. So yes, your computational data analysis falls under the mandatory exclusionary provisions. Yeah.
And a couple of more questions here. As more rights holders become global businesses, do you feel there will be much influence from overseas entities in the local process? So you mentioned that you had some international contribution to the consultation process that you were running.
Okay, you mean the influence of international
influence from overseas entities. So I guess, yeah, other people taking an interest in.
I'm just going to take this head on. This is not a Google Books exception. When we first introduced it in 2016, quite a lot of publishers and rights holders asked us, so did Google lobby for it? No, they did not. This was something we were already thinking about. Yes, much influence. I think we accept that they are part of the stakeholder groups that we need to look into. We are not saying that our copyright regime must sit within international norms as well. I mean, we're bound by treaties and agreements, but it's not a case of saying we are wholly influenced by what foreign stakeholders want, or we do not care. We do take on views. We met with entities from overseas. We even had professors from Australia, from UK, coming to meet us to give views. We had UK professors or US professors who told us, stick to fair use, it's fantastic. We had US professors who lectured us on how we should abolish fair use. We listen. I think it is important to know where our regime sits. We are a small market at the end of the day. We are buffered and influenced by factors. We are trading hub. But ultimately, we also want to make sure that what we have is a very robust regime where people feel safe to cite their IP here, to manage their IP here, to invest in R&D here. And so, yes, we take into consideration, but we look at our own unique considerations as well. I hope that answers the question.
Yeah, and I think, in the Australian context, looking at how something like a text and data mining exception would work here, I think one of the really large beneficiaries would be the university and higher education sector that would then have certainty to be developing these technologies and researching these technologies, that who are then able to implement the technologies in the real world outside of academia and commercialize them. So there's quite a big push from our government here, particularly in the education sector, to work out better ways for commercializing university research output. And research like text and data mining, machine learning, AI technologies in particular, are those technologies that are going to be booming in the future. And so I think it really makes a lot of sense for to be enabling the university sector to be able to engage in this sort of research.
Yeah, I mean, R&D is very, very important to Singapore. We do rank quite high in all those, R&D indexes and all that. And we have a lot of collaborations, a lot of university collaborations, overseas universities as well. Yeah. So that is a motivating factor, the main one, and not so much lobbying by foreign entities. I see two questions. Okay, one is about the removal of our fifth factor, the commercial availability. We understand that some people might interpret that if you remove it from the Act, how do you then know that it can still be considered? So we have, aside from having said that in all our reports, we will mention it in either the explanatory statement to the bill or in the parliamentary speech, that removal means that it's no longer a mandatory factor, but it can still be considered based on the factual circumstances of the case. And our explanatory note, as well as parliamentary speeches, have some weight at law in statutory interpretation. So that's how we would give the rights holders and users comfort on the removal. And I believe Frank, there's a chap called Frank Hill who's asking about short courses and all that. Let me clarify a little bit about the educational exception. It's a purpose-based, so we are not saying that the exception only applies to a university degree or a primary school course or short courses or certificate. It's just for the purpose of giving instruction and receiving instruction, but it is only for non-educational research, non-profit educational institutions. So it's largely your government schools. If you run a private commercial tuition center or learning center, you would not be able to avail yourself of this exception. Then you would have to pay license fees, clear rights, or rely on fair use if that is indeed the case. So the exception is a very narrow one. I hope that answers his Frank's question.
Trina, I wonder if you could also talk a little bit about the changes that the bill will introduce for the GLAM sector, particularly around the way that that the exceptions would be redrafted to be technology neutral, and how that would impact GLAM sector organisations being able to reproduce and communicate some of their information and their collections to the public.
Okay, so what we have done is we have treated galleries, libraries, archives and museums as really a group, because under the current act, I would say that the exceptions or their statutory rights are not really consistent. So some of the concerns that it came to us was, one was for exhibitions. Sometimes they would need to produce like thumbnail, images of the exhibitions for catalogs and all that. But they would have to look for rights holders' permissions. And some of these are actually orphan works, especially for the museums. And then another problem a lot of them were facing was on preservation, right? Because the provisions under our act for this group of entities were, I think, from 1987. And I'll just give you an example. Like I work with the Asian Film Archive, and they have all these films, right? And how many of those, I mean, you need to digitally preserve them. But in the act of preserving them digitally, you're creating a copy, which a lot of donation deeds back then didn't include the right to make a copy, because back then it's like, here's the negative, here's a film view for preservation, for showing, for archival, and that's it. They would not have included reproduction because they would not want the archive to reproduce in case they reproduce it for other means, but you need it for preservation purposes. So these were some of the issues that we had to tackle, which allows the libraries, the galleries, the museums, and the archives to preserve the works in a different format. And largely it's about digitization and for exhibitions as well. But we were very clear, and they never asked for it. The reproduction of the works for, let's say, exhibitions is purely for non-commercial. It does not go into the realm of merchandising. For that, it was very clear to clear rights. Now, for this group, for their exceptions, we decided to put it in the contract override, the mandatory group, where these exceptions would prevail regardless of what the contract might say. Because otherwise, they're back to square one. A donation from Mr. X would say you may do any reproduction or copying for preservation, whereas the donation from Mrs. Y doesn't mention reproduction or says that you need their permission. And your administrators are back to square one, where you sort of navigate this whole maze of contractual documents and figure out who has what rights and all that. So we decided, but again, it is limited to the national collection. It is firstly for these groups that are largely not for profit, and it is for the national collection, which is a prescribed collection under our National Heritage Board. A lot of them are donation deeds done by donation, and they relate to cultural, historical heritage and all that. So that's how we sought the balance.
Yeah, the question of preservation here has cropped up as well, and we're looking at adapting some of those changes and how they work in practice, and then making that collection available to people as well. What's the sort of second step there? I'll just quickly see if we've got any other questions to get through. So the question from Frank from before: are Singapore universities developing micro credential courses, which are short competency-based recognition? And how would the Copyright Act impact on those short courses?
I think that was what I meant. It doesn't matter whether it's a short course, a certification course, a degree, so long as the purpose is for the giving and receiving of education.
Right. Yeah. And I'll just quickly scroll back up to make sure. Oh, so having gotten near the end of the process, what would you do differently if you did it again? Yeah.
Let me share a personal anecdote. When we were close to finishing up policy recommendations, we were thinking, should we just amend the existing Copyright Act with this 16, 17 proposals, or should we rewrite the whole act? I joke with my team, maybe I should just say, let's do the amendments, let's not rewrite the whole act. It's 300 over pages and it's been quite a journey. We have a really good legislative drafter. No, but that's just a joke. What would I have changed? I'm not sure if I would change anything, to be very frank. I'm not saying it was perfect, right? Naturally, it's not. And I think in when you reform, when you change the law, when you change whatever is existing, you can't please everyone. Those who wanted the change would be happy. Those who didn't want the change would not be happy. I mean, text data mining. I mean, all of you are asking how did the publishers, the stakeholders react, rights holders react to that? Probably not very happily, but I mean, and that's the policymaker's call. You balance, you decide where the balance lies, and you just have to accept that you can't please every single stakeholder. Somebody's going to feel that they were shortchanged, or somebody's going to feel that it didn't go all the way necessary. We have to find that balance. Yeah, I suppose what I would do again is, well, actually, maybe we could have. I wish we had more time sometimes during the consultations to meet and hear from more people. It was easy to reach out to the corporate stakeholders, right? I mean, and they have a multitude of lawyers, both in-house and external, to help them. I wish what I would have done differently, or rather what I wish we could have had, were more opportunities to speak to the man on the street, the casual user of copyright, the creative, the creative person, and a lot of times it came down to what did they actually understand about copyright. So as I said earlier, some of the engagements became almost like a 101, a copyright 101. What is copyright? What is infringement? So I wish if we could have done things differently, and if the timelines had permitted, maybe we could have had more time to reach out to more people. But I think considering the whole process since 2016, we have done what I think is as possible. And it doesn't stop there. We hope to go to Parliament in the second half of this year, which is actually approaching very rapidly, and roll it, implement it, bring it into force by the end of the year. The work doesn't stop. I'll be working with other colleagues in the outreach departments in IPOS to work with industry associations to hold talks, primers on educating them of their new rights. We will have to put out lots of resources explaining things, and I'm very glad to say that. That's why I say it's been a very collaborative, consultative process. Industry associations are coming to us and say, how can we work with you? How can we work with you to ensure our members reap the benefits of some of these things? And some of them are even saying, look, I'll put aside a budget and we'll create this little pocketbook series that freelancers can read, because you're not going to give them a treatise. They're not going to read the Copyright Act. But what they would like is, I like the term they use, pocketbook. It's a short 4 or 5 pages that tell you the key things that you need to know as a photographer or as a owner of a production company. And so that's the second part of our work that we'll be embarking on next year. Yeah. Okay. That's what I have to say.
Yeah, thanks, Trina. We've got time for a couple of more questions if people would like to take a final opportunity to ask anything of Trina. I guess just while we're waiting for people to ask any final questions, I think for me, the two standout things about the bill are that it recognises the public as an important stakeholder in this process and in copyright, and I think that's really important. And the second part that really stands out for me, apart from the fact that it's just incredibly easy to read, and I think plain English drafting is a much better way forward. But I think the fact that it goes quite far to being technology neutral and adaptable to future change and future technology is really important. And that it isn't just a bill that will be drafted for technology that might exist for only the next 5 or 10 years, but really has that potential to be flexible. I think that's a really important lesson that we could take.
We were afraid that between 2019 and 2021, new technology would come in and the whole bill would become obsolete.
Yes. Well, that's right. And I think that during COVID, especially that shift, that massive shift where everyone transitioned rapidly to online learning, to working from home, to creating more online works as well, was really important.
Oh, we have one question. The voice of the copyright owner groups was louder than the voice of copyright users, especially in the education sector. I don't know if this was, no, actually, I think they louder, well, certainly there are more of them. But no, we kept in mind, like I said, the way the team work is a joint team by IPOS and the Ministry of Law. And the way it worked was that we were very clear first, what is the policy we want to achieve? And we made sure we always heard from both sides. So as I was saying, when the copyright owner groups came to us and said, your purpose-based education exception is not good for the publishing industry, and it gave us all the stats and the information. We also went back to the users, which are the teachers, the Ministry of Education, the curriculum planners, and said, okay, this is the feedback actually of what you wanted. Let's see, how can we address it? What exactly do you need? Let's be targeted. So I like to think that my team, and they're listening in, and I'd like to give a shout out to them, that they definitely tried their very best to always listen to both sides of the table and try to find that position. And as I said, nobody's ever going to be truly happy. There are things that the education users wanted and we said no. So yeah, I won't say any voice was particularly louder than the other. Yeah.
Mm. And just one final quick question, which you might be able to answer for one of our attendees, is who owns the research data under Singapore copyright law? Is it the researcher, their employee, or a research funding agency? And that one might require a little bit more unpacking.
Yeah, because firstly, if it's just data, it's not actually protected by copyright. But if you're talking about databases, there is a thin layer of copyright over that, the data, your data sets, your databases. Now, and these are literary works. So the position, it doesn't matter whether it's a manuscript or a poem or a database. It just follows who is the first owner, which is the person who created it. But if the person is an employee, so if this researcher is an employee, then I would say his employer, the research institution, would very, very likely own the copyright over the databases of compiled data, right? As the first owner, right? Mm. Unless, of course, there is a different term in the employment contract. If the researcher is working on a contract basis, then it would depend what are the terms of that contract, right? And then you add another layer of complication, the funding agreement, the funding agency. But usually the funding agreement would then change who the whether the vesting of the ownership, the copyright would eventually vest in the funding agency. Now, to my knowledge of funding agreements from the government, okay, I'm talking about government, I can't talk about your private institution kind of funding. In general, data would be freely shared, available. The output, it could be owned by the research institute, or it could be jointly owned if the government funding agency had some inventive contribution as well. So if you're talking about a full grant, right, just 100%, here's $500,000, go and do your research on this, then everything should be owned by the research institution. But if it's a collaboration, right, where the agency also provides facilities, resources, manpower, some of its own data research expertise as a collaboration, it would likely be co-owned. So it all depends on the terms of the funding agreement. Whole different topic.
Yes. Well, thank you so much, Trina, for joining us. That was a really interesting sort of overview and deep dive into some parts of the bill. So we look forward to tracking its progress and seeing it come into law.
Yeah,
which will be quite exciting. We hope so.
Fingers, everything goes well. Yeah. And thanks very much, Ben, for inviting me to this forum again. I really enjoy being here, and it's nice to hear a whole range of people asking me questions. Yeah.
Well, hopefully we'll have you back in a year or two to find out how it's all been implemented and going swimmingly. Exactly.
Well, yeah, that'd be great.
Yeah. Well, thanks everyone for joining us. We have another session running tomorrow, Friday at 1 to 2 p.m. And that is the case for a digital lending right, which will feature the Australian Society of Authors. We have Trish Epworth from ALIA and Kirsty Murray, who's an author. So look forward to hopefully seeing you at that session tomorrow. In the meantime, enjoy the rest of your day.
Thank you.
Thanks, Trina. Bye for now.